Plurality prosecution of offenses. Section 1. Criminal actions are initiated either by filing complaint or information with the court. Section 2. A complaint is a sworn written statement accusing a person of offenses, usually filed by the offended party or a public officer. Information is an accusing in written made by the prosecutor and filed with the court. Section 3. A complaint can be filed by the offended party, any peace officer, or other public officers charged with enforcement of the law. Section 4. Complaints or information are filed in the court with jurisdiction over the offenses. Section 5. The offense must be clearly designated in the complaint or information by its statutory name or reference to its provision. Section 6. The complaint or information must contain sufficient facts to inform the accused of the offense and allow preparation of defense. Section 7. The accused must be identified by name, nickname, or other means to reasonably identify them. Please, Section 8. The venue of the crime must be state unless it cannot be determined with certainty. Section 9. The complaint or information must state where the offense was committed. Section 13. Only one offense should be charged in a single complaint or information unless the law prescribes otherwise. Section 14. Complaints or information may be amended at any time before the accused enters a plea. After the plea, amended are allowed only if they don't produce accused. Section 15. If the complaint or information is dismissed, another may be filed with a dismissal is not a merits. Section 16. The court may dismiss the complaint information it is finds no probable cause. Section 17. If probable cause is questioned, the record of the preliminary investigation must be produced. Rule 111 of the Rules of the Court in the Philippines governs the prosecution of civil action in the criminal cases. It states that when a criminal case is filed, the civil action for the recovery of the civil liability arising from the crime is deemed instituted along with the criminal case unless the offended party waives the civil action, reserve the right to file it separately or the law provide otherwise. So, there are 4 prosecutor of automatic inclusion. Number 1, the civil aspect is including in the criminal prosecutor. Number 2, reservation. The offended party may be reserved the right to file the civil action separately, typically before arraignment. Number 3, dependent or civil action. Certain civil action, those based on quasi-delict, may proceed independently. Number 4, effect of dismissal. If the criminal case is dismissed, the civil action may still proceed depending on the grounds of dismissal. Rule 112, Section 1. Preliminary investigation. Define a preliminary investigation is conducted to determine whether there is probable cause to believe that a crime was committed and that accused is likely responsible. It is required for cases punishable by at least 4 years, 2 months, and 1 day imprisonment. Section 2. Officers authorized to conduct preliminary investigation. Preliminary investigations are conducted by provincial or city prosecutors and their assistants judges of municipal trial courts, of municipal circuit trial courts, or other officers has authorized by law. Section 3. Procedure. The process includes filing a complaint supported by affidavits and evidence, requiring the respondent to submit a counter affidavit and supporting evidence within a specific period. Conducting a clarifying hearing is necessary. The investigating officer then determines if there is probable cause. Section 4. Resolution of investigating prosecutor and review. The prosecutor issue a resolution starting whether there is probable cause to file charges in court. The solution of subject to review by the Secretary of Judges upon petitions. Section 5. Warrant of arrest may issue if probable cause established by the prosecutor files in information of the court. The judge evaluates the information and decides whether to issue a warrant or arrest. Section 6. When accused lawfully arrested without a warrant, a preliminary investigation is still required even if the accused was lawfully arrested without a warrant, provided they request it within 5 days from filing a complaint. Section 7. Records. The records of the preliminary investigation include the complaint, affidavits, or counter affidavits, evidence, and the resolutions. These are transmitted to the proper court of prosecutor offense. Section 8. Cases not requiring a preliminary investigation or where preliminary investigation is weak in cases where no preliminary investigation is required. Crimes punishable by 4 years, 2 months, and 1 day. Is waived. This complaint information may be filed directly in the court. Section 9. Remedies of accused. When no preliminary investigation is conducted and the accused is charged within a preliminary investigation, may be filed a motion to investigation before arraignment. Rule 113. Arrest. Arrest without warrant. A peace officer or private person may be arrested an individual without a warrant if the person has committed a crime in their presence, the person is about to commit a crime, the person is a fugitive from justice, the person has been convicted of a crime and is escaping custody, on arrest without warrant. A warrant of arrest must be issued by a judge if there is a probable cause to believe that the person committed the crime. This process typically involves an investigation by the prosecutor of a judge's evaluation of the complaint. Arrest in the flagrante delicto. A person caught committing a crime or immediately after committing it can be arrested without a warrant. Procedure upon arrest. The person arrested must be informed of the cause of the arrest and advised of the right to remain silent and to have a legal counsel. Arrest by a private person. A private person may be also arrest someone if the crime was committed and their presence must be initially deliver the person to the authorities. In short, Rule 113 addresses the situation in which a person may be arrested without a warrant. The legal procedure involves the rights of the arrested person. Rule 114, bail, refers to the provisions under the rules of the court in the Philippines, specifically addressing the process and requirements for granted bail. Rule 114 is focused on the right of the accused to be released from detention pending trial subject to the certain condition. 1. Eligibility for bail. Bail may be granted to those facing non-capital offenses, crimes punishable by imprisonment of less than life. As a matter of right, for capital offenses, those punishable by the life imprisonment or death. Bail is only granted if the accused can be proved that there is evidence of guilt strong enough to warrant detention. Judicial discretion. The court has discretions in granting or denying bail, but must take into a consideration factors like the nature of the offense, the evidence presented, and the flight rates of the accused. Bail hearing is, in a certain cases, a hearing is conducted where the prosecution and defense can present their arguments on whether bail should be granted or denied. The judge assesses whether the accused poses a flight risk or threat to the public. Condition of bail. If granted, the accused may be required to provide a safety bond of a cash as assurance of their appearance in court with required. The judge can be imposed other conditions to ensure the accused will not flee or cause harm. Exemption. In cases of rebellion, terrorism, or where the accused has committed certain grave offenses, bail may be denied or right. The essence of Rule 114, bail is a balance to the constitutional presumption of innocence with the necessity to ensure that accused individuals appear to trial and do not pose a risk to public safety. Rule 115, Section 1 of the Rules of the Court in the Philippines outlines the rights of the accused in a criminal prosecution. These rights are designed to ensure due process, fairness, and the protection of the accused constitutional guarantees. To be presumed innocent. The accused is presumed innocent until proven guilty beyond a reasonable doubt. To be informed of the nature and the cause accusations, the accused must be informed of the charges against them in a clear and specific manner to be present at trial. The accused has the right to attend their trial except when waived or in cases specified by law to define in a person or by counsel. The accused can defend themselves personally or be presented by a competent lawyer to testify and present evidence. The accused has the right to testify on their own behalf and to present witnesses to other evidence to comfort witnesses. The accused has the right to meet witnesses face-to-face and cross-examine them to a compulsory process. The accused can compel the attendance of witnesses and productions of evidence in their favor. To a speedy, impartial, and public trial, the trial must be conducted without unreasonable delays and impartially to appeal. The accused can appeal the judgment if convicted except when the law prohibits it. This right ensures the accused is given every opportunity for a fair defense and that justice is administered in accordance with due process, be aligned with the constitutional protections afforded to for every individual. Rule 116, Arraignment and Plea. Section 1. Arraignment and plea, how made, the accused is informed of the nature and cause the accusation in open court. The charges are read to them in the language or dialect they understand and they are asked to enter a plea, all guilty or not guilty or others allowed by law. Section 2. Plea or guilty to a lesser offense. The accused may plead guilty to a lesser offense if the prosecutions agree and it's permitted by law. Section 3. plea all guilty to capital offense, reception of evidence. If the accused pleads guilty to a capital offense, the court must take evidence to determine the guilt and impose the proper penalty. Section 4, duty of the court to inform accused of his rights before arraignment, and the court must ensure to accused understand the rights, including the rights of counsel, and must appoint one the accused has none. Section 5, withdrawal of improvident plea of guilty. The court may be allowed the accused to withdraw a plea of guilty if it was made imprudently or without understanding its consequences. Section 6, duty of the court of the entry of the plea of not guilty. If the accused pleads not guilty, the court set the case of pre-trial or trial. Section 7, if the accused refuses to plead or make a conditional plea, if the accused refuses to plead or make a conditional plea, the court enters a plea of not guilty of their behalf. Section 8, time for the arraignment. Arraignment must occur within 30 days from the court's receipt for the case of the accused arrest. Unless a valid delay is justified, Section 9% of the accused arraignment is the accused must be personally present at the arraignment and must enter their plea in the person. Section 10, bail of the particulars. If the accused finds the charges vague, they can request a bail of particulars to clarify the allegations against them. Section 11, suspension of arraignment. Arraignment may be suspended if the accused is found mentally incompetent, raising a prejudicial questions in a pending civil case, or involved in a pending petition for a review or the prosecution resolution. Rule 116 ensures that accused is properly informed of the charges and the rights before entering plea, with mechanism to protect against unfair treatment if allows for executivity in handling pleas and arraignments to ensure fairness and due process. Rule 117, motion to quash. A motion to quash is a written pleading filed by the accused to dismiss the case on a specific legal grounds without proceeding to trial. Grounds for a motion to quash: the court has no jurisdiction over the offense of the accused. The facts charged do not constitute an offense. There is improper venue of lack of jurisdictions over the place of the offense. The accused has been previously convicted, acquitted of the case, dismissed of the same offense, or double jeopardy. The complaint or information does not comply with the prescribed formalities. The charge is barred by prescriptions, expired time to prosecute. The officers filing the informations lack authority. The accused was not giving preliminary investigation if required by law procedure. The motion must be filed before entering a plea. If granted, the case may be dismissed. If the denial is the trial to proceed, and the accused must enter a plea effects. If the defect can be corrected, the court may order the amendment of the complaint or information. If the defect is incurable, the case is dismissed. Double jeopardy. A granted motion to quash is non-grounds like double jeopardy, prevents the prosecution from refiling the case. Rule 117 is safeguard to ensure that an accused is not subjected to the trial without proper legal basis and in violation of Rule 118 of the Rules of the Court in the Philippines governs the pre-trial stage in criminal cases, which aims to streamline the trial process and encourage resolution or simplifications of issue. Section 1. Pre-trial mandatory in criminal cases. Pre-trial is a mandatory in all criminal cases after the accused is arraigned arraigned and before the trial begins. Its purpose is to facilitate the resolution of issue, avoid delays, and promote a fair and speedy trial. Section 2. Pre-trial arraignment. During the pre-trial, the court and the parties, prosecutions and defense may be agree on stipulations of facts, waiver of the objection to evidence, marking of documentary evidence, and other matters to streamline the trial. Section 3. Pre-trial conference order after the pretrial, the court issue as a pretrial order summarizing the agreements and actions taken during the conference. This order controls the trial and limits the issue to those agreed upon. Section 4. Non-appearance at the pretrial. If the accused fails to appear without a valid reasons, they waive the right to present evidence if their defense. If the prosecutions or private complainant fails to appear, the case may be dismissed. In short, Rule 118 ensure that criminal trials are more organized, efficient, and focused on the real issue. It encourages operations between parties to simplify proceedings, saving time and resources while upholding fairness. 119 of the Rules of the Court in the Philippines outlines the procedures and rules governing the trial of criminal cases. Section 1. Time to prepare for a trial. The accused is entitled to sufficient time to prepare for the trial after arraignment. Section 2. Continuous trial under terminate postponements. Trial must be conducted continuously or scheduled dates until completed. Minimize delays. Postponements are allowed only for the valid reasons. Section 3. Exclusions is computing time for a trial. A specified period such as delays caused by motion or absence of the accused are excluded in computing the trial period. Section 4. Ground of the motion to postpone the trial. Postponement of trial is granted only for compelling reason and the subject of the court's discretions. Section 5. Order of the trial. The trial proceed as follows. Prosecutions present its evidence. Defense present its evidence. Rebuttal and sub-rebuttal evidence are presented if any closing arguments are made. Section 6. Trial in absentia. Trial may be proceed in the accused's absence if they fail to appear without justifications after being notified. Section 7. Presence of the accused of the trial. The accused must be present during the trial unless validly waived or allowed by law. Section 8. Dismissal of the case due to insufficient evidence. If the prosecution fails to present sufficient evidence, the court may be dismissed the case upon the accused's motion. Section 9. Demurrer to evidence. The accused may file a demurrer to evidence if they believe the prosecution's evidence is insufficient to warrant conviction. Section 10 to 24 is conduct of the trial and special provision, examination of witnesses, direct cross or redirect and recross examination are allowed. Admissibility of the evidence. Evidence must be relevant or competent. Submission of the case. After both parties will raise their cases, the court declares the case submitted for decisions. Judgment. The court renders its judgment based on the evidence presented. In short, Rule 119 ensure that criminal trials are conducted efficiently, fairly, and with a reasonable time frame. It emphasizes the rights of both the accused and the prosecution while providing measures to prevent unnecessary delays. Rule 120 of the Rules of the Court in the Philippines outlines the rules of the judgment in criminal cases. Below is a summary of Section 1 to 8. Section 1. Judgment. Define. A judgment is a court adjudication starting whether the accused is guilty or not guilty of the offense, charge, or determining their civil liability. Section 2. Contents of judgment. The judgment must state clearly the facts and the law upon which it is based, specify the offense, charge, and the penalty of the civil liability imposed. Section 3. Judgment in case of acquittal. If the accused is judgment must state whether the acquittal is based on the fact that the crime was not committed or the accused did not commit it. The accused is immediately released unless they are detained for another offense. Section 4. Judgment. In case of conviction, if the accused is convicted, the judgment must state the specific offense committed, the penalty imposed, and the civil liability, if any. The accused remains detained unless bail is granted or the conviction is for bailable offense. Section 5. Promulgations of judgments. The judgment is read in open court to the accused unless their absence is justified. If absence without valid reasons, the judgment is recorded in the court's minutes and name. Section 6. Entry to the judgments and penalty. The judgment becomes final after the lapse of the period to appear. With no appeal or motion to reconsideration is filed or after a higher court affirms it on appeal. Section 7. Modifications of judgment. The court may be modified if judgment before it becomes final but not after. Section 8. Executions of judgment. Final judgments are executed according to the law, which may be involved imprisonment, fines, restitution, or other penalties. Rule 121. New trial of reconsideration is a provision in a legal procedural rules that generally allows a party to seek a review for a decision of judgment in a certain circumstances. While the exact details may be varied depending on the jurisdictions. Here is a general understanding. New trial. A party may be request a new trial if there is evidence of errors, irregularities, or new facts that could impact the fairness or outcome of the original trial. Grounds for a new trial often include misconduct by a party or jury, newly discovered evidence, legal errors during the trial, improper admissions of evidence, verdict against the weight of the evidence, reconsiderations. Reconsiderations, a motion of reconsiderations asks the court to review the decisions of judgment before it becomes final. Typically, filed when a party believes that the court overlooked or misapplied the law of facts. This is not a chance to re-argue the case but to address clear errors to prevent manifest injustice, procedural requirements. This motion must usually be filed within a specific time frame after the judgment or decisions. The filing party must be clearly state the grounds and provide supporting evidence or arguments. Court authority, the court has discretions to grant or deny this motion based on the merits of the arguments. And the impact of the justice, if you need to specify details, let me know the legal framework or jurisdictions you're referring to and I can provide a more tailored. Rule 126, Search and Seizures. Below is a summary of Section 1 to 4. Section 1, Search of warrant defined. A search warrant is an order issued by a judge directing a law enforcement officer to search and seize specified items based on probable cause. Section 2, Court where application for search warrant is failed. Application for a search warrant are filed in any court within the judicial region where the crime was committed or where the search will be conducted. Section 3, Personal examination of the applicant and witnesses. The judge must be personal examine the applicant and the witnesses to determine probable cause before issuing a search warrant. Section 4, Particularity of place to be searched and item to be seized. The search warrant must clearly specify the place to be searched and the items to be seized to avoid general or exploratory searches. Section 5, Issuance and validity of search warrant. A search warrant is valid for 10 days from issuance and must be executed within this period. Otherwise, it becomes void or grounds for the issuance of search warrant. A search warrant may be issued for personal property subject to search and seizures as an instrument, product, or evidence of the crime. Violations of laws or ordinances. Section 7, Right to break a door or window to execute warrant. Law enforcement officers may be break open a door or window if access is denied after announcing their authority and purpose. Section 8, Search of a house, room, or premises to be made in the presence of the witnesses. Searches must be conducted in the presence of the lawful occupant or two witnesses to prevent tampering or abuse. Section 9, Time to search. Searches must be conducted during daytime unless the warrant specify otherwise. Section 10, is safe for property seized and other executing. The warrant must be provided a detailed receipt for the items search of the lawful occupant of the witnesses. Section 11, delivery of property and the inventory to the court. Seized item must be delivered to the court with a detailed inventory for proper documentation and disposition. Section 12, search and incident to a lawful arrest. A lawful arrest allows to the warrantless search to the person arrested and the immediate premises for weapons of evidence. Section 13, prohibitions against use of evidence, obtain illegal evidence through unlawful search and seizures is admissible in court. Section 14, motion to quash a search warrant or suppress evidence. The accused may be file a motion if the warrant of suppress evidence is the warrant was unlawful issue or the search was improperly conducted. In short, that the searches and seizures are conducted legally and with respect for individual rights if emphasize judicial oversight or in specificity and accountability while providing evidence of violation of procedural safe.